Hello everyone, so myself Gaurangi Kushma and today I'm again back with my another video on burden of proof under the Indian Evidence Act 1872. So let's get started. First of all, let us understand what is the burden of proof. In the simple terms, burden of proof is the responsibility to prove the fact in a case. Each party must provide a fact that will either stand for or against the case. The term burden of proof is used to explain two major facts or burdens. The first is the burden of production, of the burden of going forward with the evidence, and the burden of plea or persuasion. The burden of plea is the responsibility that rests on the single party through the period of court sittings. The party carrying the burden can only succeed in its claim once it has absolutely satisfied the tier of fact. For one to be presumed innocent in the court of law over a criminal case, the prosecution is faced with the burden of proof elements of the offense and disapprove all defenses, excluding defenses with affirmation which constitutionally are not required in the prosecution of the case. The evidential burden should not be confused with the burden of persuasion. Evidential burden can change hands between parties during the court proceedings. The evidential burden is only raised to provide enough evidence against a case in the court. Principles of burden of proof. The underlying principles of the burden of proof are contained in the concept of onus probandi and factum probans. In this explanation, onus, burden is the liability and obligation to prove a fact which can shift between parties in the case. Section 101, 102, and 103 of the Indian Evidence Act provides the standard laws that governs the burden of proof. Section 101. This section, in its explanation on burden of proof, states that whoever wants the court to proffer judgment to a legal case or right based on the availability of facts must prove those facts beyond any reasonable doubt. Illustration. In a case that a person A desires the court to offer judgment on B following crime committed, A must prove that B has committed the said crime. A has prayed to the court to give judgment that he is to own a certain land which presently is possessed by B based on the facts he present which B has denied. In this case, A must prove those facts to be true. Section 102, burden of proof lies. In a case brought before the court, the burden of proof lies who has the tendency to fail if no evidence is supplied before the court for either of the parties. Illustration. If A takes B to court following a feud because of a land which B is in possession and A asserts that it was left to A following a will made by C, who was B's father. If neither A or B present any evidence, then B will retain the property. In a case where A sues B for money resulting from a bond, both parties have agreed to the execution of the bond, but B disagrees that it was contracted by fraud, which A disagrees. If no party can establish an evidence, then A would win as the bond has been contracted, but the case of fraud cannot be proved. In that case, the burden of proof rests on B. Section 103, burden as to a fact. The burden of proof to a fact rests on the person who desires the court to believe in the existence of such facts unless a law authorizes the proof of the fact to be established by any particular individual. Illustration. If A sues B for theft and desires the court to accept that B admitted committing the theft to C, A must prove that fact, and if B denies it, B must prove it. The principle of the section states that once a party desires the court to accept and act based on the existence of a fact, he must prove that fact. This principle is called rule of convenience of burden of proof and is contained in the section 104, 113, 113A and 114A. Section 105, burden of proving that case of accused comes within exceptions. When a person is accused of an offense, the fact required to establish the circumstances surrounding the case, excluding general exceptions in the Indian Penal Code 45 of 1860 or in any regulations defining it, it's upon him, while the court will presume the absence of such a circumstance or not. Section 106, burden of proving facts, especially within the knowledge. When any fact confined to the knowledge of a person, the burden of proving that fact is on the person. Illustration: the burden of proving the fact is on a person who commits an act with the intention which is different from the circumstances that the act suggests. On an occasion that A is charged on boarding a train without a ticket, the burden of proving such a fact is on A. Section 107, burden of proving the death of a person known to have been alive within 30 years. In a situation of a controversy, whether a person is dead or alive, and it is established that he had been alive for the last 30 years, the burden of proving that he is not alive is on the person who states it. So now let's move to the conclusion of this video. The rule governing the burden of proof is that whoever lays a claim must present evidence or proof. This rule is subject to the principles that the burden of proof rests on the party that either asserts a claim or denies it. This implies that whoever brings a case against another to the court must prove the fact he claims. In criminal cases, the burden of proof on defendants is based on the evidence that is established before the court, which states that the fact that he committed the crime as adduced. An accused can only be presumed guilty based on the fact established by the plaintiff to the court in accordance with the burden of proof that rules in the case. So by this, I end my video here. Thank you so much, and I hope you all have understood well. So stay safe and stay healthy.